Welcome to Crime Before Modern Law. Here, we explore how crime and justice functioned before modern policing. If you find this topic interesting, feel free to leave a comment telling us where you are watching from. And if you would like to support the channel, a like or subscription always helps. For most of human history, courts did not work the way many people expect today. In many places, there were no professional police departments, no public prosecutors, and often no lawyers speaking for ordinary people in everyday cases. That did not mean there was no law. It meant that law was carried out through local custom, community obligation, written rules, religious norms, and the authority of rulers and judges. People often had to speak for themselves. This documentary explains how courts could function without lawyers, and what no legal representation really looked like across different times and systems. The focus is on procedures: who started a case, who gathered information, who decided facts, how decisions were enforced, and how people tried to protect their interests when they had no trained advocate. First, it helps to define what a lawyer means in this topic. In modern systems, lawyers usually do several jobs at once. They explain rules, file documents, select legal arguments, cross-examine witnesses, negotiate settlements, and protect a client from procedural mistakes. In many earlier systems, these jobs were split apart or handled by different people. A person might get advice from a local expert, a clerk, a priest, a notary, or a respected elder, without that helper ever speaking in court. 2. There might be specialists who could write documents but not argue the case. 3. There might be speakers or advocates for hire, but their role could be limited or only available to wealthy people. 4. In many criminal cases, the court itself was expected to question the accused and the witnesses directly, instead of leaving that to lawyers. So courts without lawyers does not always mean courts without any legal professionals. It often means the ordinary person had limited or no right to have a trained representative speak for them, especially in lower courts or in serious criminal trials. A second key idea is that older courts often aimed for a different kind of order than modern courts. Today, courts are strongly shaped by detailed statutes, broad rights to counsel, formal evidence rules, and professional policing. Earlier courts were often built to do at least 5 basic tasks: keep peace in the community, settle disputes before they grow into feuds, collect fines, fees, and payments, confirm social obligations like service, rents, or local duties, show public authority so people accept the system as legitimate. With that in mind, we can examine how procedures worked when most people had to speak for themselves. In many small local courts, the main engine of justice was not lawyer versus lawyer debate. It was community participation. In medieval and early modern parts of Europe, local courts could include manor courts, village courts, borough courts, hundred courts, and county sessions. Procedures varied by region and century, but many shared a similar pattern. The court met on scheduled days at a known place. Officials opened the session, called people forward, and recorded outcomes. Cases were raised by private complaint, by local officers, or by community presentment, meaning a group reported what was happening in the area. People accused or complained about appeared and answered directly. A group of locals, sometimes called jurors, doomsmen, or suitors depending on the time and place, played a role in reporting facts, judging reputations, or confirming local knowledge. The court imposed a result, a fine, an order to pay compensation, a pledge to keep the peace, or a direction to do or stop doing something. The written record, if one was kept, might be brief. A clerk might write the names, the issue, and the decision, not a full transcript. In this style of court, the case often depended on practical questions rather than technical legal arguments. Who owes what? Who crossed a boundary? Who broke a rule the community already knew? Who failed to appear after being summoned? The process often favored people who could speak clearly, gather supporters, and show that they were reliable members of the community. Without lawyers, the biggest advantage was often social and informational. People who understood local custom, who had allies, and who could navigate the court's expectations had better results. That brings us to a crucial point. Without legal representation, procedure itself becomes a major source of power. In formal systems, mistakes can end a case. In many older courts, there were also procedural traps, wrong words, missed deadlines, failure to bring proper witnesses, failure to make a required oath, or failure to follow the right sequence. Even if a person was right in a moral sense, the court might still rule against them if they did not perform the process correctly. Because of this, many societies developed substitutes for modern representation. One substitute was the use of clerks and scribes. As courts became more record-based, paperwork mattered more. Many people could not write or could not write in the court's language. So they used someone who could draft a complaint, write a petition, or copy a statement. This helper might be a clerk attached to the court, a town official, a religious figure, or a paid scribe. In these settings, the helper often did not argue the case in the modern sense. They shaped it by putting it into the right written form. Another substitute was oath and reputation systems. In many places, proving a claim was not mainly about physical evidence. It was about sworn statements and trusted standing. A person could swear an oath and bring oath helpers, people who supported the oath not by describing facts, but by supporting the swearer's credibility. If the community believed one side was more trustworthy, that could decide the case. This is one reason why older courts often punished false accusation and false oath harshly. The system depended on the idea that sworn speech could be reliable. A third substitute was settlement pressure. Many courts tried to push disputes toward compromise. The judge, elders, or local leaders might aim to get the parties to accept a payment, apology, boundary agreement, or peace pledge. In a world without strong enforcement tools, a workable settlement could matter more than a perfect ruling. Now we turn to higher-level courts and more formal legal systems, where the question becomes sharper. How did serious trials work if the accused had limited or no right to have counsel speak? A well-known example comes from England's criminal trial tradition. For a long time, English felony trials were shaped by a rule that sharply limited defense counsel on matters of fact. Counsel might be allowed on points of law, but the accused often had to answer the case personally when it came to factual disputes. This created a trial style that does not match modern expectations. In that older format, the judge played a much more active role. The judge could question witnesses, summarize evidence, and steer the proceeding. The idea was sometimes expressed as the judge acting to prevent unfairness, rather than relying on defense counsel to do it. But an active judge is not the same as a defense lawyer. A defense lawyer's job is to advance the defendant's best case. A judge's job is to manage the court and reach a lawful outcome. Even if the judge tried to be fair, the accused still faced a major problem, responding under pressure in public while not knowing the rules of proof and argument. When trials rely heavily on direct questioning of the accused, the procedure is also different in a basic way. Modern systems often treat the defendant's silence as protected, and they structure proof around investigations and evidence gathered before trial. Older systems could rely more on the accused responding in court, explaining, contradicting witnesses, or trying to show good character. That made speaking ability, composure, and social standing very important. Another major setting for courts without modern lawyer-centered procedure is Roman law. Roman legal procedure changed over time, but one continuing theme is that not every case was a lawyer-driven contest. In early and classical Roman civil procedure, there were phases that relied on formal steps and then judgment by a lay judge. The process typically began with the parties being brought before a magistrate, who decided whether the case could proceed and how it would be framed. Then the case could be assigned to a judge who was not necessarily a legal professional, but a respected layperson. Advocates did exist in Roman life, and speech-making could matter, especially for elites. Still, the system was not built around the modern idea of every person having a trained representative with full control of the case. In later Roman cognitio procedure, more of the case came under control of an official judge. The state took a stronger role in summoning parties, hearing the matter in a single forum, and enforcing decisions. This can reduce the need for private legal combat, but it also increases the importance of dealing correctly with officials and documents. In many civil law traditions that developed later in Europe, courts became more document-centered and judge-directed. That also changes what without lawyers looks like. A judicial process can, in theory, be more accessible because the judge can ask questions and request information. But it can also be difficult because the system still has rules, and success may depend on written petitions, timing, and knowing which facts matter. Another major model is the Islamic Qadi court tradition. In broad terms, the Qadi was a judge who decided disputes using recognized legal principles within Islamic law. While practices differed by place and era, a common procedural concept was that the plaintiff carried the burden of proof. Evidence could include witness testimony and oaths. Legal representation could exist through an agent or representative, often described as a wakil, but the court did not operate like a modern adversarial trial, where two lawyers control questioning and argument. The judge's role could include managing the process, evaluating proof standards, and encouraging settlement. In many pre-modern systems, especially where communities were close-knit, the court was also a place where the judge already knew local realities or had access to local knowledge through trusted people. That may sound efficient, but it can create risks. People outside the local network may struggle. Marginal groups may face credibility problems. Decisions may reflect social rank more than neutral fact-finding. These are not assumptions about every case. They are structural pressures common in systems where proof depends on reputation and social standing. Now consider the difference between civil disputes and criminal accusations. In many earlier settings, criminal and civil were not separated the way they are today. Many wrongs were treated as private harms that could be resolved with compensation, fines, or peace agreements. As states grew stronger, certain wrongs became public offenses, acts seen as threats to the ruler's peace, the community's safety, or religious order. When a wrong becomes public, procedure changes. The community or the state has a stronger interest in punishment, but without professional prosecution and defense, courts still needed ways to decide. Common tools included formal accusation rules, sometimes with penalties for false accusers, community reporting or presentment, judicial interrogation, use of written depositions in some systems, ordeals or compurgation in earlier medieval contexts, later replaced by jury and witness-based methods in many regions. Over time, many jurisdictions moved toward more evidence-based procedures, but that did not automatically create a right to counsel. In fact, one reason some systems limited defense counsel was the belief that truth could be reached through straightforward questioning, and that skilled advocacy might confuse matters. From a modern viewpoint, it is easy to see the risks of this idea, but historically it fit a world where courts were smaller, proof was often personal, and the judge was expected to manage much of the inquiry. When people lacked lawyers, they used other strategies to protect themselves. They prepared by gathering community supporters. They sought character witnesses. They obtained written statements from local officials. They tried to frame the dispute as a matter of custom everyone recognized. They used delay or procedural steps to buy time. They settled privately before a final judgment. In property disputes, they might rely on charters, boundary markers, or remembered agreements. In debt cases, they might rely on account books, witnesses to a loan, or sworn denial. A person who could not do these things was at a disadvantage, even if the formal rulebook said both sides could speak. Another question is enforcement. Modern courts rely on police and state systems to enforce judgments. Older courts often relied on a mix of enforcement tools, fines, and amercements, which were money penalties. Seizure of goods, community pressure, including the threat of being treated as outside the peace. Pledges and sureties, meaning someone promised money or responsibility if a person did not comply. Imprisonment in some contexts, often as a way to hold a person until payment or trial, not always as a long-term sentence. Public punishments in serious cases, especially when authority needed to be shown. If you did not have a lawyer, understanding enforcement mattered. Sometimes the real goal was not to win, but to avoid the harshest enforcement outcome. That leads to the topic of plea and confession. Many systems valued confession as the strongest proof. Without legal protections and defense counsel, a person might be pressured by circumstances to admit wrongdoing, or to accept a settlement that avoided worse consequences. In judicial systems, the judge's questions carried great weight. In community-led systems, reputation pressure carried great weight. In both, the absence of a trained defender changed the balance. Now we should explain how the gradual rise of professional legal roles changed courts. As governments expanded and legal rules multiplied, procedure became harder for ordinary people to manage. Written pleadings became longer. Deadlines and filing requirements became stricter. Legal categories grew more technical. Appeals became more common. At that point, speaking for yourself no longer meant what it meant in a small local court. Even if a system still claimed to be open to all, the practical need for specialists increased. This is one reason why, in different places, societies developed professional advocates, attorneys, notaries, and later modern barristers and solicitors. But the spread of lawyers did not automatically mean equal access. Representation often depended on wealth. Some courts restricted who could plead. Some criminal procedures limited defense counsel, even while allowing prosecution counsel. In England, major reforms in the 1800s expanded the ability of people accused of serious crimes to have counsel speak fully. These changes reflected a shift toward understanding that complex evidence and formal procedure could not be navigated safely by an untrained defendant. A similar shift happened in many modern states. The right to counsel became connected to the idea of a fair trial. In the United States, that transformation took shape over time through constitutional law and later landmark rulings. But the broader historical point is that earlier courts could function without lawyers, mainly because procedure and expectations were different. So how did courts work without lawyers? They worked by using court designs that reduced the need for professional advocacy, at least in theory. The designs relied on 5 main supports. First, they relied on community knowledge. Instead of treating every case as a technical puzzle, many local courts treated disputes as known social conflicts. People were expected to know local custom. The community's role was to report, confirm, and enforce. Second, they relied on formal speech acts. Oaths, sworn denials, and set forms of complaint provided structure. Even when writing was limited, the system had scripts people were expected to follow. Third, they relied on judge control. In many higher courts, the judge managed questioning and guided the process. This reduced the need for lawyers to perform examination, but it also concentrated power in the judge. Fourth, they relied on settlements and peacekeeping. Courts often aimed to restore order, not only to declare legal truth. Compromise, compensation, and pledges were tools to end conflict. Fifth, they relied on unequal access to helpers. Even when lawyers were not allowed, or not common, many people still used legal knowledge through informal advisors, scribes, and local patrons. The system could operate, but it often favored those with connections. Finally, it is important to correct a simple misunderstanding. Courts without lawyers were not necessarily simple, fair, or informal. Some were highly formal, with strict words and steps. Others were informal, but socially demanding. Many could be efficient at handling large numbers of minor disputes. But for outsiders, the poor and the socially weak, the lack of representation could be a serious barrier. The central lesson is that legal representation is not just an added feature. It changes the whole shape of procedure. When lawyers are missing, courts tend to depend more on community pressure, on judicial questioning, on standardized oaths, and on written clerks rather than oral advocacy. In that environment, a person's ability to speak, their reputation, and their support network can matter as much as the underlying facts. Understanding these older systems helps explain why modern legal rights developed the way they did. As law grew more complex and punishment more severe, the idea that an ordinary person could safely defend themselves in a formal court became harder to maintain. The growth of professional policing, professional prosecution, and professional defense was not just a change in jobs. It was a change in how societies tried to find truth, keep order, and define fairness within the courtroom.